Good day, ladies and gentlemen. Welcome to the Labor and Employment Interworking Conference Call. At this time, all participants are in listen-only mode. If anyone requires assistance during the call, please press star and 0 on your touch-tone telephone. I'll now like to turn the conference over to your host, Ms. Kristen Martin. Ma'am, you may begin.
Thank you. On behalf of Foley and Lardner, we would like to thank you all for participating in our Interworking web conference series. Today's conference will last 60 minutes. During this time, you may submit questions by selecting the Q&A button and typing in your question. We will try to answer all of your questions. However, if we run out of time, we will follow up with you individually after the conference. If you would like to print or save a copy of the PowerPoint presentation, you may do so by selecting the printer icon at the bottom right-hand corner of your screen and downloading. Please note, in order to receive CLE or HRCI credit, you must be logged into both the computer as well as the telephone line. If you have any questions, you may email me at kmartin@foley.com. I would now like to introduce you to your presenters for today. First, we have Jack Lord, a partner in our Orlando office, Carmen Cowden, an associate in our Milwaukee office, and John Litchfield, an associate in our Chicago office. Jack, you may begin.
Thank you, Kristen. Again, my name is Jack Lord. I'm a partner in Foley's Orlando office. And today we're going to talk about the ADAAA regulations that just recently came out. And we've been dealing with the new ADA since January 1, 2009, but now we have clearer guidance from the EEOC about what they're looking for, and of course the courts now have clearer guidance to help them in determining whether or not you as employers are following the new ADA with respect to your employees. I'm going to give a brief background for everyone historically, just placing in context where we are now and how we got here with the ADAAA, the Americans with Disabilities Act Amendments Act. And then John Litchfield is going to give an overview of the changes, a side-by-side, not extremely in-depth analysis, but in-depth enough for you to get the practical considerations for what has changed and to help you in your workplace in dealing with employees who may not have disabilities, who may or may not need reasonable accommodations. And then Carmen Cowden is going to give some further guidance on what you as employers should be looking at now. The landscape has definitely changed in how you're going to be dealing with employees with disabilities. We know that the ADA, the Americans with Disabilities Act, first came about in 1990. And it had a predecessor, the Rehabilitation Act, and so it wasn't a brand new law covering people with disabilities, but it was brand new in covering most private employers. Similar to Title VII, of course, it covers employers who have 15 or more employees. Back in 1990, when the first President Bush signed the ADA into law, he said the following: I know there may have been concerns that the ADA may be too vague or too costly, or may lead endlessly to litigation. But I want to reassure you right now that my administration and the United States Congress have carefully crafted this act. We've all been determined to ensure that it gives flexibility, particularly in terms of the timetable of implementation, and we've been committed to containing the costs that may be incurred. Let the shameful wall of exclusion finally come tumbling down. And with that, the ADA came into place, and of course, it has had very good effect with respect to making sure that people with disabilities do get fair treatment in the workplace. I think the first President Bush was a little off, though, on some of his predictions with respect to litigation and the cost of that. And I'm going to go through some of the Supreme Court cases that came about later in the 90s and into the early 2000s. By 1999, the EEOC charges that had been filed, the district court cases that had been tried or disposed of on summary judgment, and then the circuit court cases that had gone up, the intermediate courts of appeals, had wound their way through. And in 1999, the first big ADA case regarding Title I, which is employment, was handed down by the U.S. Supreme Court. There were some companion cases we have cited there as well that came out. But Sutton versus United Airlines, that was a very key case, and it frankly led to, as we'll show you, the Americans with Disabilities Act Amendments Act and all the changes. In Sutton, the court looked at whether or not, in reviewing if a person had a disability, the court would need to consider corrective or mitigating measures. So, for example, would the court look at a person who has visual impairment and consider that the person wears glasses? Or would the court look at a person who has diabetes and consider that the person takes insulin, corrective or mitigating measures that could actually do away with the impairment? And the court answered, you do look and you do consider those mitigating measures. So if the insulin will fix the problem, the diabetic may not be disabled under the law. And as you can imagine, that cut a lot of individuals out from protection under the ADA. In 2002, the Supreme Court continued kind of narrowing, limiting the ADA, and in Motor Manufacturing, Kentucky, the Williams case, the court implemented a very tough and pretty narrow standard for other courts to use in determining whether employees were substantially limited in major life activities, some concepts that John's going to talk about in a little while. Again, this type of Supreme Court ruling narrowed who was covered by the ADA and led later to the Amendments Act. Something worth noting is that during the 1990s, upwards of 83 to 89% of all ADA cases were resolved in favor of employers, many, if not the vast majority, on the basis that the person who had sued simply did not have a disability as defined by the ADA with the Supreme Court's definition of disability. Turning to 2007, there was a lot of outcry for changes. In July of that year, the ADA Restoration Act was proposed. Now, that one didn't pass, and one of the main reasons was there was substantial opposition, and I think understandably, from groups because there was an attempt in that first revision to remove the requirement that a disability substantially limit a major life activity. John's going to get into the compromises that were done, and but substantial limitation of major life activity is still one of the definitions we have. In 2008, the law that did ultimately come to pass was proposed, the ADAA Amendments Act. And fortunately, there was agreement. There was a lot of communication, there was a lot of education, and there was a lot of cooperation among the different groups. SHRM, the Society for Human Resource Management, obviously a pro-employer business side group, came and gave its input and agreed to the changes that were ultimately proposed. The American Diabetes Association, obviously a pro-employee and disabled person group. Then on the other side, National Association of Manufacturers. Then on the other side, American Association of People with Disabilities. So broad support. September 11 of 2008, the bill passed the Senate unanimously. September 17 of that year, the bill passed the House unanimously. And September 25, 2008, the second President Bush signed the ADA Amendments Act of 2008 into law. In January, that law became effective, and I'm not going to go into great detail, but here are some highlights of the changes. The mitigating measures, that was that first Supreme Court case I pointed out. The law was revised to say you don't take into consideration mitigating measures, other than certain things like corrective lenses, glasses, contacts, things like that. In this law, there was an expanded list of major life activities. We'll talk about that. A big change, big change, is that this new law creates a much more generous standard for regarded as cases. And, of course, there are three ways that a person can bring a disability claim: having an actual disability, having a record of having such an impairment or disability, and then third, being regarded by the employer as disabled. And we're going to focus in our presentation because you as employers are going to need to focus in your workplaces a lot more on disregarded as prong. Ultimately, here's a way to think about the ADAAA. The question of whether an individual's impairment is a disability under the ADA should not demand extensive analysis. So what the law says now is, courts, we want you to look at that first element of a claim, whether or not the person has a disability, and decide that really quickly. We don't want to have to bog down and have a mini trial. We don't want to have a lot of doctors and other scientific evidence in the process. Just like with other discrimination claims based on race or gender, whether or not the person is in a protected category is obviously an element, but we don't want to spend a lot of time on it. Now I'm going to let John Litchfield, an associate in our Chicago office, tell you about the ways the changes have come about and what the courts do want you to focus on now, what Congress wants you to focus on now.
Thanks, Jack. Like Jack said, I'm an associate here in the Chicago office, and I'm going to do a bit of a comparison as to what happened after the ADAAA came into effect and now the EEOC regulations, and refer back a bit to what Jack talked about, particularly with the Sutton and the Toyota cases, since those were the landmark cases in narrowing the scope of what a disability is. So let's start with the scope of a disability and what the definition is. Under the old ADA, if I can get my slides to work. Well, anyway, under the old ADA, the definition of a disability, as Jack said, was a physical or mental impairment that substantially limited a major life activity, a record of such impairment, or being regarded as having such an impairment. This was narrowly interpreted by the Toyota case, which actually said that this should be strictly interpreted to make it such that the disability, it's difficult to establish that a person has a disability. Lower courts followed suit in this. After the ADA was passed, part of the purpose that Congress said was that they wanted to make sure that it was much easier to demonstrate that an individual, that their impairment met the definition of disability. And the purpose of this was to cut down on the analysis of whether a person has a disability and go straight to whether there was a violation of the ADA Act. Congress, in passing the ADA, overruled the Supreme Court's definition in Toyota, and it also overruled the formerly narrow scope of the EEOC regulations. So now, for example, persons with epilepsy, diabetes, MS, bipolar disorder, major depression, and other impairments that had previously been excluded from the definition of disability are now able to meet the definition of that. The focus, like I said, is now on the merits of the claim rather than determining whether an individual has a disability. This isn't necessarily a win or a loss for employers, except for the fact that now the merits of the claim become much more important to defending a claim rather than discussing whether an individual actually has a disability. So moving along, what is a disability? Well, the definition itself didn't really change all that much. You still have this three-pronged definition as to what a disability is. So it's a physical or mental impairment that substantially limits a major life activity. The substantially limits and the major life activity elements of the first prong are important also to the second prong. And those two prongs actually are important to determining whether an individual needs an accommodation. Under the third prong, as Jack said, which is commonly referred to as the regarded as prong, it states that when an employer takes an action that's prohibited by the ADA because of an actual or perceived impairment that is not both transitory and minor, the employer may be liable. And we'll talk about what transitory and minor is a bit later in the presentation.
Yeah, just let me jump in real quick. It used to be under the old ADA that before we had these terms transitory and minor, again, John's going to highlight for you what that means now. We had maybe not necessarily bright line tests, but there were court cases that were useful in showing that if something didn't last 6 months, then it may not really be a disability. Something, obviously, under the FMLA can be up to 12 weeks and be a serious health condition. And there was that little gray area between 12 weeks or 3 months and then 6 months. And employers needed to be definitely careful as to whether or not they were considering something not to be a disability if it was in that area. But there was still good court guidance. These new regulations kind of take away those, it really do take away those useful court cases talking about 6 months. And John's going to have to give you some of those definitions later.
Yeah, thanks, Jack. One other thing to note under the regarded as prong is that it doesn't necessarily, in fact, it does not entitle an individual to a reasonable accommodation. So if a person is suing under this prong, they don't have to show that they were denied a reasonable accommodation by the employer. All they have to show is that the employer regarded them as having a disability and that they took an action prohibited based on that regarded as prong. So moving on to the definition of substantially limits. A disability substantially, under the former ADA, impairment was substantially limited to a person if it prevents or severely restricts an individual. And the Toyota case actually was the case that decided that, and it determined that because the Congress used the word substantially, it meant that it really should be a narrow definition. This was a big win for employers because it made it more difficult for individuals to establish that they were substantially limited by a major life activity. Under the new EEOC regulations, however, an impairment need not prevent or severely or significantly restrict major life activity. This means that basically Congress overruled Toyota by specifically including this language in the ADAAA, and the EEOC adopted that language as well. The purpose of this was to have a broad interpretation of what substantially limits actually means. And what Congress, or what the EEOC did, is they created these so-called 9 rules of construction that help both employers and individuals determine whether they have a disability. A couple examples of these 9 rules of construction include that an impairment does not need to prevent or significantly limit a major life activity to be substantially limiting, but not every impairment will constitute a disability. Another example is that the regulations emphasize that an individualized assessment is the only way to determine whether a major life activity actually is substantially limited by the impairment. And one further and kind of important rule of construction is that the determination of a disability does not require an expensive analysis, which is what Jack talked about earlier. And this just points to the fact that Congress really didn't want people to focus on whether a person has a disability, but rather the merits of the claim. So basically, this is this slide here illustrates the importance of the individualized assessment. And basically, Congress said that there should be a common sense assessment based on comparing an individual's ability to perform a specific major life activity with that of most people in the general population. So it's a comparison of a person's ability against most people in the general population. Congress also, or the EEOC, stated that this doesn't necessarily need to include a scientific analysis or any kind of data. It can be a judicial notice, basically, and arguments by the parties to determine whether this person's impairment, as compared with others in the general population, is considered substantially limited their major life activity. As we talked about earlier, an impairment lasting for less than 6 months now can be substantially limiting. This was not the case before, or at least it generally wasn't. So if something now is considered to last less than 6 months, it can certainly be substantially limited. However, under the regarded as prong that we talked about earlier, If the impairment is transitory and minor, then the individual is not covered by the ADA. And transitory and minor is defined as a impairment that will last for less than 6 months. So essentially, an impairment that lasts for 6 months or less can be considered a disability under the first two prongs, but may not be necessarily under the third prong of the definition of disability. So moving on to what a major life activity is. This is another element under the ADA that has been changed. So under the old ADA, major life activity had to have been of central importance to most people's daily lives, and it had to be permanent or long-term. And this was from the Toyota case. Under the ADAAA, there's actually a long list, kind of a laundry list of new major life activities, but it's a non-exhaustive list. One other major change is that the major life activities list includes now major bodily functions, which was not included in the previous ADA. Additionally, even short-term conditions can be considered sufficiently severe to be considered a major life activity. Again, this is important mostly for the first and second prong of the definition of disability. Moving on to the next slide, which actually goes into a bit more detail on major life activity. Some of the examples there that you can see are caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, etc. The addition of major bodily functions, like I said, was a more important addition. And some of those examples include functions of the immune system, special sensory organs, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, and other functions. Again, this is a non-exhaustive list, but it provides some examples of what Congress considered to be major bodily functions.
Hey, John, before you move on, I just want to point out that some of those major life activities were subject to a lot of litigation, like the lifting major life activity. In a lot of instances, courts would not consider lifting 25 pounds or more to be a major life activity, and therefore you couldn't show that you were disabled if you had some kind of a condition that prevented you from lifting that amount. Now it's expressly in there. Again, it just shows how difficult it's going to be to argue that somebody does not have a disability. Congress added so many things in here, including the major bodily functions, that it's really just, you're going to not focus on this section when you are trying to decide whether or not somebody needs to be accommodated or whether or not you have a situation with potential disability in your workplace.
That's exactly right. And the comparison that I talked about earlier to the general population is really important. So, for example, if a person can't lift 15 pounds, but an ordinary person can, that employee can be substantially limited in the major life activity of lifting, whereas before that wasn't necessarily the case. And as I started to say, the purpose of adding major bodily functions to this list of major life activities is to make the list easier to find individuals with certain types of impairments that have a disability. So, for example, cancer is one that is an impairment, I guess, that was litigated over before and wasn't necessarily considered a disability because it wasn't always impairing a major life activity. However, now cancer, as we know, impairs cell growth, impairs normal cell growth, and thus it can now be considered a disability because normal cell growth is considered a major life activity. Another example is HIV or AIDS, because it impairs the immune system, and it could actually, depending on whether the person is medicated, affect other major bodily functions. So these are two examples that will almost always be considered major life activities now, whereas before they weren't always. In terms of the major life activity of working, the Sutton case dealt with that, which Jack talked about a little bit earlier. And the Sutton case said that substantial limitation of the major life activity of working, it must be shown that the person had an inability to perform a broad range or a class of jobs, not just one particular job. This actually was pretty much maintained in the new, the ADAAA, But the difference is that an employee will now probably be found to have a substantial limitation in another major life activity rather than that of working. So the goal was to eliminate the major life activity of working determination and broaden the scope to really determine whether people are impaired or not. Moving on to mitigating measures, which Jack talked about a bit earlier. Under the old ADA, as he said, mitigating measures were actually used by courts in determining whether a person was substantially limited in a major life activity. But the ADAAA specifically overruled the Sutton court there, and now the positive effects of mitigating measures must be completely ignored when determining whether a person has a disability. The focus should be on whether an individual would be substantially limited in performing a major life activity without the mitigating measure. So, for example, if somebody is taking a medication that alleviates the symptoms of their disability, though the medication itself can no longer be considered when determining whether a person has a disability. On the flip side of that, the negative effects of a mitigating measure can be considered in determining whether a person is substantially limited. For example, the side effects of medication for a particular impairment that have negative effects can and should be considered in the individualized assessment that the person undergoes. Some examples of mitigating measures are medical equipment, prosthetic limbs, hearing aids, mobility devices, and additionally reasonable accommodations. So if a person requests a reasonable accommodation, you can't determine whether that will alleviate the symptoms until after you've determined whether the person is substantially limited in a major life activity. And again, this just highlights the importance of the individualized assessment now. Further, the prohibition on assessing the positive effects of a mitigating measure only applies to whether an individual meets the definition of a disability. And as Jack mentioned earlier, the rules on mitigating measures do not apply to glasses or contact lenses. That's just a pretty straightforward element that was specifically noted by the EEOC and the regulations. So another thing to note is that the determination of whether there's a need for a reasonable accommodation, which is the second part of an ADA analysis, or if a person poses a direct threat to others, the employer can consider both the positive and negative effects of mitigating measures. So, for example, if an employee at a trucking company takes a medication for an impairment and a side effect of that causes him to be drowsy, although the assessment of whether the impairment is a disability may not consider the side effects, either the positive or negative effects of the drug, the fact that it causes him to be drowsy may be considered in determining whether the driver poses a direct threat to others when operating the truck. So basically it eliminates, this mitigating measure eliminates whether a person can be considered to be limited in their major life activity when determining whether they have a disability, but not in the second part of determining whether they need a reasonable accommodation or pose a direct threat to others. The next important thing to note are the episodic conditions element that was added to the ADAAA. Prior to the ADAAA, there was a narrow interpretation of what the ADA meant, and that certain impairments were not considered disabilities. Those included epilepsy, HIV, PTSD, cancer, irritable bowel syndrome, and obesity. Now, under the ADAAA, episodic or impairments, or even those in remission, are disabilities if they substantially limit a major life activity when they're active. And the important thing to note on this is that it's not whether they're active at the particular moment, but whether they actually would, if they ever became active, whether they would limit a major life activity. What this means is that a chronic impairment with symptoms or side effects that are episodic rather than present all the time can be a disability even if the symptoms would only major the life activity when the impairment is active. An example, again, is cancer in the sense that when it's in remission, it's not affecting or causing a limitation on a major life activity, but it is possible that cancer will return and it will substantially limit the major life activity of normal cell growth. Epilepsy is another example. Individuals can go years without having any symptoms, but that doesn't mean that they don't have a disability. So, as Jack mentioned, the regarded as prong is actually substantially expanded in terms of employer coverage, or coverage of individuals now. Under the old ADA, liability under the ADA existed where the employer regarded the employee as disabled and that it substantially limited a major life activity. Now it only matters that the employer regarded the individual as having a disability. There no longer needs to be a showing that the employer actually believed that the perceived disability limited a major life activity, and employers will be considered to regard employees as having a disability anytime he or she takes an action prohibited by the ADA that's based on the impairment that the employer believes the individual has. Again, an example can be cancer. An employer that does not hire someone or refuses to promote them because they think they have cancer, whether or not they actually do, has regarded the person as disabled. This is a big expansion from before because the employee had to show that it wasn't only that the employer regarded them as having a disability, but that disability, whether or not it actually existed, would impair a person's ability to perform a major life activity. There are some defenses, however, to this regarded as prong. First of all, the legality of an employer's actions is a separate inquiry from determining whether a person has a disability. Just because a person has a disability doesn't necessarily mean that an employer's actions are illegal. And the same goes for whether just because the employer regarded the employee as having a disability, it doesn't mean that a failure to hire or a failure to promote is prohibited by the ADA. That's because the individual still has to be qualified for the job that they're applying for or that they are seeking to be promoted into. Additionally, the EEOC specifically states that a valid defense to the regarded as claim is where an impairment is transitory or minor. We've discussed this a couple of times, but that basically means that it's expected to last for less than 6 months. However, this has to be a objective determination. So where an employer fires an individual because he or she has major depression or sickle cell anemia, it cannot assert that the disability was transitory or minor, even if it is supposed to last less than 6 months or something along those lines. And that's because that's objectively not the case. Major depression is considered now under the new ADA a disability, and so is sickle cell anemia. So whether the person has it or not, the employer can't assert this defense where it's not objectively a transitory and minor disability. So giving you that kind of outline of what the new ADA actually encompasses, Carmen's going to talk a bit more about what that means for employers and how you can use this information to hopefully mitigate any litigation costs that may arise out of this new exposure that the ADAAA may give to employers.
Thanks, John. Before moving on to sort of what all of this means, I just want to follow up on a couple of things related to the regarded as prong. Certainly the regarded as prong has changed, the definition has changed, but in some ways it's actually changed to benefit employers a little bit, because in order to have a regarded as claim, you actually have to have some kind of prohibited employment action, some sort of adverse employment action in order to even have a regarded as claim. So for example, one of the things that used to crop up in the past, employers would call and say, you know, hey, if I send somebody for a fitness for duty exam because I don't know whether or not they're able to perform their job or whether they have some sort of limitation that I should be accommodating, am I going to run into problems with a regarded as claim because is it going to look like I think they have a disability when they really don't? This new definition of regarded as actually helps employers in that regard because sending them off for a fitness for duty exam or sending them off to get further information about the condition isn't going to give rise now to a regarded as claim because there's no adverse employment action. You didn't refuse to hire them. You didn't terminate them. You didn't force them to go on leave, that kind of a thing. You actually have to have that employment action before you even get into the regarded as claim. So that's just one little thing that actually turned out to benefit employers when these definitions changed.
And the other, Carmen, the other actual big benefit in the regarded as prong is that these new regulations expressly say that reasonable accommodation does not, absolutely does not apply to the regarded as prong. The courts were mixed on that before, whether or not you had to reasonably accommodate somebody simply because you regarded them as being disabled. Now that's expressly not part of the law.
That's right. Okay, so anyway, what do all the changes mean for employers now that we have these expanded definitions? Well, the big thing is that because we have more conditions that are now going to meet that lowered disability threshold, the focus when we're looking at disability claims is going to shift from whether or not a person has a disability to other considerations that we typically look at with respect to disability claims. For instance, we focus on employee qualifications and whether or not an individual is qualified to perform the job. There's also going to be an increased focus on whether or not employers promptly engage in the interactive process with employees to determine whether there's some sort of accommodation that the employees need. And then, of course, there's going to be increased focus on the reasonableness of certain accommodations. Again, each of these areas, there's nothing new about them. The law didn't change with respect to these particular areas and what employers are required to do, but these are going to become the areas of focus now because we no longer are able to rely on the fact that somebody won't be considered disabled under the law because that threshold has changed so much. With respect to employee qualifications, this is going to be one of the, I think, primary battlegrounds for employers who now have to litigate these disability claims. Again, it's going to shift from whether they have a disability to whether or not they can perform the essential functions of the job and therefore are qualified. The employee does still have the burden to prove that he or she is qualified, but it's going to be up to the employer to make sure that they can articulate what functions are essential and what performance standards the employee is going to be required to meet in order to be able to say that he or she is able to perform her job. These things, both the essential functions of the job and what performance standards are applicable, are going to be measured at the time of the adverse action at issue. So if it's a hiring claim, it's going to be measured at the time that the employee is applying and is rejected. If it's a termination claim, it's going to be measured at the time that the employee's employment is terminated.
And that's important because of those, the new thing about conditions that are in remission, conditions that are episodic. So we're not going to be able to rely on the fact necessarily that the person can't work 6 months later if it's a hiring claim and the person could perform all essential job functions at the time of hiring.
That's right. As far as the essential job function analysis goes, some of the things that the courts have looked at in the past and will continue to focus on in the future are things like, what does the job description say? This is a big one because even though it's not it's not dispositive in that just because the job description says something is an essential function doesn't mean that it automatically will be characterized as that by a court that's looking at it down the road. But it is important. If it's not in there at all, you know, there's certainly an argument for the employee to say, look, it's not even in my job description. How can it be an essential function? And so what the job description says is going to be an important factor in assessing whether or not a certain function is essential.
And I think that should be a huge takeaway for everybody on the phone, and it's one of the most difficult things to do is to keep up-to-date written job descriptions, but it's really, really, really important. It's the first thing we're going to ask for when we're defending an ADA claim. What does the written job description say as far as essential job duties? And it's really, as Carmen said, it might not be dispositive, but if it's not written down in there, how can it be that important? A judge or a jury is going to wonder. So keeping those up to date is so, so important.
And by the same token, you might want to think about including in your job descriptions things that are that are really common sense. I mean, have to be able to work with, cohesively with others. Has to behave appropriately and be able to follow conduct rules. Has to be able to stand for long periods of time if it's a standing job. Those kinds of obvious things that when you look at it, you say, well, of course they have to do that. Those things can be included in the job description. There actually, oddly enough, have been a few courts, and again, these are just a few courts, but that have actually said, look, there's nothing in here that says he's got to be able to get along with other people. There's a question whether this is really essential function. I mean, it sounds silly, but you might want to actually include some of those obvious things in your job description. In addition to the job description and what that says, another factor in determining whether something is an essential job function is whether or not the employee is requiring that all other employees satisfy those same requirements. It's hard to argue that a job function is essential if you've only got a certain portion of the workforce engaging in those job functions, or if you've made exceptions for other people in the past for whatever reason. It's really, really hard then to later try to hold somebody to that standard and make them perform that job function if we've made exceptions in the past. Likewise, the amount of time spent performing the particular job function is going to be an issue. Again, here there's not really any bright line. It's not if they perform this function more than 50% of the time or more than 90% of the time. You might have a function where it's only performed 10% of the time, but it's really, really key. But still, that's going to be a factor. And if it's something that you only have to do once a year and maybe it's not a really big deal if that function gets portioned off to somebody else, that's going to be a factor to be considered. This fourth factor is very important, and it kind of goes back to what I was just saying about the amount of time spent performing the job function. You're going to want to look at the consequences of eliminating or reassigning the job function. For example, one of the things that has come up in court cases are situations like firefighters. Well, the amount of time that they perform actually putting out a fire is pretty small in comparison to a lot of the other duties that they engage in. But the consequences of saying, hey, you firefighter, you don't have to put out fires is huge. I mean, it essentially eliminates the whole reason for the job. So that's going to be something that's going to be deemed essential to the job, regardless of the fact that they may only have to do it once in a while. And then the fifth factor is collective bargaining agreement provisions. The courts typically are pretty deferential to collective bargaining agreement provisions. And so if there are provisions in the agreement saying that these particular functions are part of these particular jobs, that's something that the courts are going to look at in determining whether or not something is an essential job function. With respect to the employer's legitimate performance standards, this is an area that is helpful for employers because employers are basically allowed to set whatever production and performance standards they deem necessary to get the job done in their workforce. And employers are allowed to require employees to meet those production and performance standards. So you can have rules and you can have requirements related to attendance and productivity, rules of conduct, safety standards that have to be met, and employees can be required to meet all of those things. Again, you have to make sure that they're going to be applicable across the board, and you're not making exceptions for employees here and there because it's going to be hard to defend if we've made exceptions for some employees but not others. And again, in terms of the actual performance and production standards, you're going to want to make sure that there's some legitimate business reason for those standards, and then they aren't just arbitrary. With respect to the interactive process, this is going to be one of those areas that the EEOC and courts in general are going to be focusing on, because in the past, again, a lot of times we didn't even get to this point because we were able to get rid of the case because the employee didn't have a disability. But now there's going to be an increased focus on this, and employers are going to want to make sure that their workforce is trained properly and they know what to do in the event that an employee comes to them and gives them some sort of notice that they might need an accommodation because of a disability. Note that the obligation can be triggered by an employee request or by the employer having knowledge of the employee's disability and having some other indication that the employee may need an accommodation. So, you know that this person has a back injury, and you see the supervisor sees them every day struggling to lift something. That might be a situation where it's incumbent upon the supervisor or HR, really HR is better, to go get involved and find out whether there's something that the employee needs by way of an accommodation. The big thing with the interactive process is that you got to engage quickly. You can't just, let 6 months go by and hope that it improves. There are situations where courts have found that an employer's delay was unreasonable and therefore was evidence of disability discrimination. So you want to make sure to engage quickly if there's any indication that someone might need an accommodation because of a disability. As I said, supervisors, because they're on the front lines, should be trained on what to do if they suspect an accommodation is needed. And really what they need to be trained to do is to go bring that to HR's attention. They don't have to get involved in the discussions with the employee right there on the floor. They just need to bring it to HR's attention so that HR can follow up and find out if there is anything that can be done to assist the employee. Supervisors in particular, but also HR, need to remember that there aren't any magic words that are needed to trigger the employer's obligation to engage in the interactive process. The employee doesn't have to say, I have a disability and I need a reasonable accommodation. They don't even have to say, I need some kind of an accommodation. It may be as simple as saying, I hurt my back and I'm having some trouble lifting this, and I don't know what I'm going to do. That can be enough. They don't have to say reasonable accommodation or disability. They do, however.
Carmen, we got a question that I think it'd be worth answering right now. One of the participants asked about they operate a call center, and they have an employee who has issues with migraines and calls in late, and it seems like they don't know when the person's going to be there. And do they have to, continue to allow these absences and just try to scramble, or what can they do with respect to this situation? I think it's definitely worth making everybody feel better that everyone is on this phone at some point or other most likely will get a reasonable accommodation request of time off. That's the most common, I think, reasonable accommodation request out there. It's obviously a burdensome one when you have a situation where you're trying to staff and you need people there at a specific time. There's a lot that goes into the analysis on that question I just read to you. One thing would be whether or not a migraine in and of itself would be a disability under the law. Despite all these changes, it's not the Americans with Boo-Boos Act. It is the Americans with Disabilities Act. And so in and of itself, a migraine situation may not trigger the ADA. Certainly it could, most likely would, be a serious health condition under the FMLA and require that. That's not necessarily the case under the ADA, that it would be a disability. And then it goes, and Carmen is right here in the interactive process, it goes towards whether or not that is a reasonable accommodation, whether or not certain amounts of time off would be reasonable. Certainly the FMLA, since it allows up to 12 weeks of time off, that's a good guidepost for an ADA situation. so that even if the person's not FMLA qualifying, if they need up to 12 weeks of time off, that's probably going to be, depending on the job, but most likely it will be a reasonable accommodation. Notice does need to be given, so the person, just like under the FMLA, under the ADA, the person can't just fail to follow your call-in procedures, but it just points out that time off is one of, if not the most frequently requested accommodations, and this interactive process that Carmen is going through right now is very, very important in time off scenarios.
Thanks, Jack. So with respect to the interactive process, again, the goal is to basically analyze what job functions are at issue, what are the barriers to performing those functions, and then what are the possible things that the employer could do that would eliminate those barriers. It's not all on the employer, though. I mean, both the employee and the employer are responsible for helping to identify possible accommodations that might remove those barriers. And again, as I said earlier, the accommodation does need to be because of disability. You know, if somebody calls in and says, I'm tired all the time, and I really just need to come to work later, that may or may not get into the area of disability. We don't know why they're tired. There are lots of people that are tired and wish that they could start a little bit later, but that in and of itself, just calling in and saying, I'm tired all the time and I need to start late, doesn't indicate that there's an accommodation that is needed because of a disability. If they call in and say, you know, I'm waking up late all the time because I have sleep apnea, then you're into that area where, you need to start having a dialogue because there's some indication that it's because of disability. Also, just because more conditions will meet that disability threshold now, doesn't mean that the employer has to just go ahead and assume that somebody is disabled. The employer is still entitled to get reasonable documentation from the employee about his or her condition and how that would limit his or her abilities and his or her ability to perform the job. If an employer requests documentation of that sort and the employee fails to provide it, or the doctor for whatever reason doesn't provide it, that failure can result in a breakdown in the interactive process that will typically be pushed off on the employee as being the fault of the employee, because the employee does have that burden to provide the information upon request. As far as the area of reasonable accommodation goes, it's important for everyone to remember that reasonable accommodation does in fact mean that there is preferential treatment required in terms of providing reasonable accommodation. Just doing what you do for everybody else just isn't enough, and so employers have to be careful with no exception type policies. Things like, you know, we're never going to adjust our attendance policies because this is how the policy is and this is how we do it for everybody. There can be cases where you have to look at whether adjusting a particular policy would be a way of accommodating somebody's disability. So you have to be careful with those things. But keep in mind that the employer does have the right to choose any accommodation that will eliminate the barrier to working so long as it's an effective solution. The employee doesn't have the right to say, well, this is what I want. I don't care that you can provide me this other accommodation that will work. This is what I want, and that's the only thing I'm going to take. In that case, it's the employee, again, who's going to be responsible for breaking down this interactive process, and the employer has the right to stick to its guns and say, no, this is what we can provide. This will work. Some examples of accommodations that have been found by the courts to be reasonable, I'll just let you take a look at those, but again, a lot of these relate to modifying work schedules, providing leave, reassigning someone to open positions, or modifying equipment, or in some cases, non-essential job functions. On the other hand, things that have been found to be unreasonable are indefinite leave, where the employer has absolutely no idea when the employee is going to be able to return to work. Open-ended schedules, where the employee is essentially asking the employer to let them come into work whenever they want to. That's been found to be unreasonable. Rescinding discipline is a big one. Get a lot of questions about whether because an employee who is going to be disciplined comes into the meeting and says, oh, you know what, that's because of this condition, that's why this happened, whether or not the employer has to rescind the discipline. And most of the courts and the EEOC have said, no, you absolutely don't have to rescind the discipline. You need to look at the condition and engage in the interactive process to determine whether some modification or some change to a policy might be necessary going forward, but you don't have to go back retroactively and rescind discipline based on a violation of a legitimate policy. A couple other things. Reassignment has been found to be unreasonable if it requires the employee to be promoted or to bump another employee. Lowering the employer's productivity standards, it has been found to be unreasonable. Assigning the employee to a new supervisor and modification of seniority policies have also been found to be unreasonable. With respect to reasonable accommodation, again, we've said this over and over, but the focus for employers now should really shift from what is the condition and how is it affecting the employee to what is it that the employee needs to be able to perform their job. That is, of course, unless there's some doubt that the condition exists, in which case you can go back to those things we've talked about in requiring documentation and asking for further information about the actual condition.
Hey, Carmen, one of the questions we just got was about what types of documentation would be good. The employer, as Carmen mentioned, you are allowed to ask for accommodation as long as, of course, both the condition and the need for accommodation are not obvious. So if a person's in a wheelchair and telling you that she needs a ramp, you cannot demand documentation of that sort. But if the person has some type of undetectable condition and you cannot tell right away, on the surface of it, what the need for accommodation is, you can certainly request that. And we have forms. You can certainly contact your Foley attorney to get that. There are forms similar to like you would send to a healthcare certification form for the FMLA. Forms like that will ask the appropriate questions under the ADAAA to see if the person has a qualifying impairment, qualifying disability, and need for reasonable accommodation.
With respect to, again, reasonable accommodation, for the most part, the changes to the ADAAA are going to result in employers just simply, if something can be done without much cost or without much burden, in really just doing it, because it's going to be more costly and more burdensome to try to figure out, okay, is there a way to get out of doing this than there is to just do it now that more and more people are going to be covered by the definition of disability. That said, if there's an accommodation that is costly or is going to create some kind of undue hardship, or if you have some doubt about whether an employee has a condition, then you're going to go back and you are going to focus on that condition. You're going to make sure that you get the documentation. You're going to look at all of the factors as to whether or not you might be able to avoid providing that accommodation, or you might have a good basis for not providing that accommodation because there is some sort of undue hardship to you as the employer. On the issue of undue hardship, this is an area where very rarely does litigation get far enough that there was some discussion about the undue hardship defense, because again, the cases typically got resolved at one of the earlier stages on the issue of disability or the issue of qualifications or the issue of an employee not engaging in the interactive process. So we didn't get very often to this undue hardship question. But now being able to demonstrate undue hardship is going to be more important for employers who deny accommodations for employees who do satisfy this lower disability threshold, because again, we're not going to have that after the fact defense to be able to say, well, they didn't really have a disability. They didn't really meet that tough definition under the law. In terms of what's considered in proving undue hardship, the courts look at the nature and the cost of the accommodation, the financial resources of the facility, the number of employees at the facility, and the effect on their expenses and resources. They look at the overall financial resources of the the employer in total, the size of the business and the number, type, and locations of its facilities. And then they look at the type of operations of the employer and the geographic separateness in administrative or fiscal relationship between the employer overall and the facility in question. Employers, when it comes to the undue hardship defense, if you're all the way through the process and you're coming down to a situation where you're going to deny a reasonable accommodation because it's an undue hardship, you've got to be really careful about concluding that it's too costly. Because what's going to happen, if that's your articulated defense, is the courts are going to say, okay, well and fine. If we want to talk about what's too costly, let's look at all the other kinds of things that you, employer, spend money on. And it's going to open up, essentially, the company's financials and their billing and cost practices to a court's review. So you've got to be really careful about just sort of reaching that conclusion that it's too costly. By the same token, effect on employee morale is typically not been enough to establish undue burden. There are a number of cases where employers have said, look, you know, this isn't fair to my other employees. They're getting upset because I'm providing this accommodation to this individual and they don't get the same thing. The courts have said, no, that's not enough. It's not enough to establish an undue burden. The best angle has typically been that there's some sort of actual adverse effect on other employees. For example, it's causing them to have to take on additional assignments or take on additional duties that they're not required to perform. Or another good angle is that it essentially requires the employer to ignore its own legitimate performance standards. So, for example, you know, we're allowing this person to put out less product during the course of a week than everybody else is something where the employer's having to say, look, this is what we said is required for this job, and we're now asking the employer to modify that. That's typically been deemed to be an undue hardship. The big thing on these undue hardship defenses is simply that you're going to have documentation to prove it. You're going to have to be able to show it. It's not going to be enough for the plant manager to walk in and say, well, that was just too tough for us to do. You're going to have to be able to point back to some analysis and some documentation of having gone through the process and really assessed whether or not it was an undue hardship. So I guess with that said, we're a little bit over time here, I know, but I know there are a couple of questions. We can certainly maybe take a couple of questions now, Jack or John, if you've looked at them and if there's any that we want to try to answer real quickly. And if not, any we don't get to, we can sure go ahead and contact you by email afterwards to answer those questions specifically.
John, do you want to look at some of the questions? We'll probably, let's answer one or two, and then everybody can drop off as needed. Well, one of the questions here was about making sure the forms that employees sign are HIPAA compliant. That would be an issue if you're a healthcare provider. Certainly, no doctor is going to give the medical information without a release form from the employee, and so that's why I say contact one of your lawyers. There are forms that you should use, and definitely the more notice to the employee, the better. As Carmen pointed out, in fact, I see this frequently, where an employee is requesting a reasonable accommodation of some sort, but is refusing for whatever reason. It may be as extreme as the condition doesn't actually exist, but it may be simply just resistance for privacy issues. The employee won't get the forms back from the doctor. And as long as the employer documents that, gives reasonable time, I would, under the FMLA, the employee has 15 days to get the healthcare certification form. I would say that under the ADAAA, that amount of time would be reasonable. If the employee doesn't get it back, you document, you tell the employee that, and I would document this, say that your failure to get these documents back to me from your healthcare provider will result in me, the employer, considering your request for reasonable accommodation to be deemed withdrawn. And if you don't do it by a certain date, the consequences could be, for example, if the employee is not returning to work and is requesting an absence, a termination due to excessive absenteeism. So that's documentation. Just anytime we talk about labor and employment law, that word comes up over and over again. Documentation is so key with respect to these changes to the ADAAA. I think that's a very good place to wrap up, actually. Document, document, document.
Okay, thank you all again for participating in today's web conference. Please take 2 minutes to participate in our brief online survey that just popped up on your screen. You may now disconnect.
Ladies and gentlemen, this concludes today's conference. Thank you for your participation and have a wonderful day.